Welcome to Canton Confidential. We are now in week 2 of jury selection for Karen Read's second murder trial. Thanks for joining us, everyone. I'm J.C. Monahan.
And I'm Glenn Jones. 16 jurors are needed before opening arguments can begin. Today ended with no new additions. That means there are still 6 seats to fill to round out the 10 jurors chosen last week.
We know Read's defense team is asking the Supreme Court to delay her retrial. We obtained their application to stay the state court proceedings, and we'll let you know if and when any decision is made.
Our John Maroney has more on that, today's court proceedings, and an encounter with Read herself outside of Norfolk Superior Court.
I mean, it's going at the same pace as last year, despite more publicity.
The search for impartial jurors in the murder retrial of Karen Read, much more than a numbers game, as Judge Beverly Cannoni looks to find 12 jurors and 4 alternates.
That's probably a tribute to Judge Cannoni running a good, tight ship and everybody sort of staying on track with how they're going through the process.
Read has pleaded not guilty to hitting her boyfriend, police officer John O'Keefe, with her SUV and leaving him to die in the snow. 45 potential jurors were in court Monday for day 5 of the selection process.
You know, really this process is for both sides is mostly, and especially the defense, is about deselection, not selection, right? Making sure people who are going to have a bias aren't sitting on the jury.
Here's a look at the impressions of this latest jury pool. 91% say they've heard of the case, 70% say they've formed an opinion, and 29% say they have a bias either for or against Karen Read.
This was the smallest pool we've had today.
The 45-year-old defendant filed a petition with the U.S. Supreme Court last week to have 2 of the charges against her dismissed, including second-degree murder. She now wants the High Court to delay her trial and was asked about the Supreme Court intervening.
To quote Shawshank Redemption, hope is a great thing, sometimes the best of things. So I'll take any chance with the Supreme Court, Ted.
Thank you. You told a lot of movies, Karen.
I've been watching a lot. I've had some time.
So far, 344 potential jurors have been screened. Between 80 and 100 are expected here Tuesday. In Dedham, John Maroney, NBC 10 Boston.
So we still have a bit of a ways to go. Michael Coyne, our trusted legal analyst, is back with us tonight. Michael, let's just start here. What's your take on the fact that the defense, once again, is going all the way to the Supreme Court to try to get this thrown out, or 2 of the charges thrown out?
They're going to exhaust all avenues. Frankly, I think she's got a better chance of hitting the lottery than the Supreme Court taking that appeal. I don't see the stay applying either. I think they're going to allow this case to move forward to trial.
Okay. Go ahead.
Michael, I wanted to go back to a question that was asked last week because it got an interesting conversation going. It came from Megan. She wanted to know if the jury should be sequestered in the second trial. Your colleague, Morgietta, she thought maybe it would be a good idea. And then we talked to a juror from the first trial on Friday, Ronald Estanislao, and he said he thinks it's the appropriate thing to do as well. So I wanted your take, but also to understand, how do we get there? I mean, does the court just impose it, or does one side have to request it?
Well, a side would normally request it, but the trend these days is against sequestration for a bunch of reasons. Obviously, you want the jury to be removed from any potential influence adverse to their ability to decide the case. But if you look at the more recent cases where there's been any sequestration, that was the George Floyd murder by Derek Chauvin. That was 4 years ago. Bill Cosby, 7 years ago, they sequestered the jurors. The problem is, in a 2-month-long, 2.5-month-long trial, A, the expense is significant, and then B, they're removed from their families. There's pressure that mounts internally there, and some juries, believe it or not, when they have been sequestered, then see it almost as an occasion to engage in spring break. We've actually read a case in our evidence book with the students with respect to a jury really engaging in inappropriate behavior during sequestration.
So unlikely here, you would say?
I don't see it, simply because the jurors would have been told already that that is likely, and they could plan their lives accordingly. They'd also plan their excuses. Since none of that happened, even if it might be prudent to do so to remove them from it, there's drawbacks to it as well. And since it hasn't been announced, they're not going to do it.
We're going to just briefly talk about the audit into the Canton Police Department before we go. There was a public meeting on Saturday. They went over the findings from the audit of the Canton Police Department. That report was released the same day jury selection began. It did highlight some mistakes during the investigation into John O'Keefe's death. The public, again, got to voice their opinions on the report for the first time Saturday, and they asked a lot of questions.
Would you have wanted this audit to happen if this exact situation was happening in your town?
I recently read a comment from someone running for the select board that the Canton Police is a two-tier system and that many community members were afraid to call 911. There were also comments that certain residents were receiving VIP or preferential treatment. I was wondering, during your audit, did you find any evidence of that?
Now, Michael, as it relates to the John O'Keefe investigation, the report said it found no preferential treatment, no cover-up, no conspiracy. But I think there is a lack of confidence maybe in this police department and maybe other small-town police departments as a result of what was revealed here.
I think it makes everyone question a little more what we believe to be proper procedures and keeping our community safe. And the report pointed out a number of deficiencies with respect to the collection and preservation of evidence, but they also pointed out that they could find no evidence of a conspiracy. And so that's what the interesting evidentiary question now becomes is, will the prosecution want to use it in part? Will the defense want to use it in part? Prosecution is going to have more problems using it, and the defense may not want to use it because of it undercuts one of the significant parts of their defense.
If I was heading up a police department, though, especially in a smaller town, when I was reading through a portion of this, the thing that stood out to me was the budget. They didn't have the money for the training that the officers needed. In this case, a death investigation. Doesn't happen a lot in Canton, thankfully, but it turns out that they were missing some key items, both in their patrol cars and in their experience. What can these other local departments do so that we don't end up having to go through this again because of a lack of either the budget or the training?
I think all my friends in law enforcement would tell you we need more money, lots more money, and therefore then we have the ability to train our folks better and give them better equipment. And in part, with respect to the equipment here, remember the first obligation of those responders at that point in time was to try and save John O'Keefe's life. And so the preservation of the evidence at the scene took a secondary role. And I do think that we sometimes forget there that they believed that they might still be able to save his life. And so obviously being very careful on the scene and everyone wearing gloves and not taking steps that would have been much more preferable to preserve evidence for a murder investigation. The goal at that point was to see if there was any way to save his life.
Yeah, that occurred to me too. In hindsight, but at the moment you didn't know what you were dealing with.
Right, hindsight's 20/20, right?
Always. Michael, as always, thank you. We do want to take a moment, though, to honor former Boston police officer John O'Keefe. There's a new billboard that is paying tribute to him in his hometown of Braintree. You see it there. You can see it if you're driving 93 along the Braintree split. It features two photos you can see of Officer O'Keefe, as well as the phrase, "Remember him." And that is exactly what we want to do tonight. We've learned a lot about John O'Keefe's life outside of being a police officer.
He made an immense impact on so many.
The world knows John O'Keefe as a proud Boston police officer of 16 years. The people who knew John intimately call him Johnny and say the job he loved most was being legal guardian to his niece and nephew.
Johnny moved into their house in Canton, the original house that Steve and Kristen had bought. He moved in with the kids there.
John's older sister, Kristen, tragically died from an illness, and just months later, her husband died too. Their kids were orphaned. A little girl aged 6 at the time, her brother aged 3. The O'Keefe family, in court every day of the trial, was devastated.
My wife and I had talked about having the kids come live with us. We had 2 small children at the time. 3 and 8 months were my children. We didn't have a large enough house to take on 2 other children, so my brother stepped in, moved into the house in Canton and raised them for 8 years.
From 2013 up until his death, John O'Keefe loved the kids as his own and would constantly show up for his friends' families too.
We were close. We did a lot of stuff together, pick up the kids, drop the kids off.
Him and my husband would always do the games. The kids used to call them my 2 dads. It was like they had a lot of fun together.
John's friend Michael Camerano on the stand said he'd go to the O'Keefe's household every Friday night. He knew John and all of his personality traits.
Everything was very tidy. When you walked in the door into the house, to the left, you put your shoes, your coats would be hung there.
And as far as shoes were concerned, is that something that you wore inside the house? Or?
He'd rather you not.
That day in January, John and Michael both had something to celebrate. The kids got school acceptance letters. A proud dad moment.
We were just congratulating the girls, talking about how good it's going to be, different school, and just really excited for the girls.
Another close friend testified later in the trial, Laura Sullivan. She dated John's friend Pat, became pregnant with Pat's child, but in 2013, Pat took his own life.
Immediately following that, John never really left my side, as a support system.
John would become godfather to Laura's son, another way John O'Keefe stepped up for his friends' families, for his own family. He was 46 years old.